program. Please carry on.
Good morning to distinguished guests, Honorable Mr. Justice Swatanter Kumar, former Chairman, National Green Tribunal, New Delhi. And very good morning, distinguished Honorable Justice Michael D. Wilson, Justice, Supreme Court, State of Hawaii, USA. And very good morning, P.K. Malhotra ji, distinguished Professor, School of Law, Sharda University, former Secretary, Union Ministry of Law and Justice. Today, all of us, the School of Law is organizing a series of webinars. And today, protection of rights to life and right to livelihood during COVID-19 pandemic. The world is facing an unprecedented crisis. At its core is a global public health emergency on a scale not seen for centuries, requiring a global response with far-reaching consequences for our economic, social, and political lives. The priority is to save lives. It is time for society to use this pandemic as an opportunity towards increasing the value of human life in a more qualitative way to create a society that truly understands what Mahatma Gandhi dreamt said, it is health that is real wealth and not pieces of gold and silver. Should we save lives or livelihoods? That is the question. The question has put policymakers, citizens, scholars in a quandary. Other questions include how long should public health be prioritized over economic prosperity? By temporarily shutting down the economy, is the cure becoming worse than the disease? Until when can we sacrifice the nation's economic potential and livelihood? Governments across the world have the unenviable task of striking a harmonious balance between spending on health and providing an economic stimulus to those most in need, enhancing employment benefits and minimizing corporate insolvency. It is only by walking this tightrope that we can achieve the most optimal outcome of minimum health care burden and maximum economic recovery. 3 human rights are at front line in the current pandemic. First one is right to life and duty to protect life. Second is right to health and access to health care. Third one is the central challenge to freedom of movement. Emerging human rights challenges in the impact of the crisis on the employment, food insecurity, widespread closure of schools, and uninterrupted the education of uninterrupted the education of more than 1 billion children and fear of unemployment go on. The Constitution in the Part 3 guaranteed fundamental rights, with Article 21, right to life and liberty, being a right which cannot be abrogated at any cost. A few rights which have been encompassed under Article 21 through judicial pronouncement or legislative amendments are right to health, right to food, right to privacy, right to livelihood, and right to education. The current situation poses a new test every day for executive and the judiciary. For the executive, it is a test to enforce the law of the land and guarantee the fundamental rights provided by the Indian Constitution. For the judiciary, it is the test to uphold those rights which have been denied by the state in an attempt to uphold and protect the constitutional fabric. The executive and the judiciary need to constantly reevaluate the state of affairs. Now I request Honorable Dean Dr. Pradeep, School of Law, Sharda University, to welcome the guest, please.
Thank you very much, Dr. R.P. Yadav. It is my distinct privilege to welcome Honorable Mr. Justice Kumar, former Judge Supreme Court of India and former Chairman National Green Tribunal, New Delhi. Presently, Honorable Justice is leading professor of law Honorable Mr. Justice Michael D. Wilson, the Supreme Court, State of Hawaii, USA, and Mr. P.K. Malhotra, former Secretary, Union Ministry of Law and Justice, in this international webinar on protection of right to life and right to livelihood during COVID-19 pandemic. Honorable Mr. Justice Swatanter Kumar, for his sterling contribution as a judge of the Supreme Court of India, Judge and Chief Justice of High Courts, and Chairperson of the NGT, has been bestowed with 12 different awards, including National Law Day Award, Lifetime Achievement Award, International Human Rights Award, Bharat Jyoti Award, Distinguished Services Award by the Indian Medical Association, and awards by other national and international organizations. Mr. Pragati, you please mute others. Honorable Justice has authored various leading judgments in the field of constitutional law, arbitration, and environmental jurisprudence. We welcome you, Honorable Mr. Justice. Honorable Mr. Michael D. Wilson, Judge, Supreme Court, State of Hawaii, USA, was appointed to the Hawaii Supreme Court on April 14, 2014. Prior to being appointed to the Hawaii Supreme Court, Mr. Justice Wilson served as a circuit court judge for Hawaii First Circuit. He previously served as the Director of Hawaii Department of Land and Natural Resources, Chair of the Board of Land and Natural Resources, Chair of the National Water Commission, and various other positions. Mr. Justice has authored many leading judgments in the field of constitutional law and environmental jurisprudence. We welcome you, Honorable Mr. Justice. Mr. P.K. Malhotra is the former Secretary, Union Ministry of Law and Justice, and Distinguished Professor in the School of Law. He has more than 40 years' experience in the field of law in various capacities, out of which he has worked in the Ministry of Law and Justice for more than 25 years. I will switch off my video so that audio is better. Just excuse me for 1 second. Now I believe audio will be better. I'll repeat, Mr. P.K. Malhotra is the former Secretary, Union Ministry of Law and Justice, and Distinguished Professor, School of Law. He has more than 40 years' experience in the field of law in various capacities, out of which he has worked in the Ministry of Law and Justice for more than 25 years as an officer of Indian Legal Service and reached the apex level of Union Law Secretary. We welcome you, sir. In 1776, the United States Declaration of Independence declared that all men are created equal and they are endowed with their creator with certain unalienable rights. Among these are right to life, liberty, and pursuit of happiness. The right to life is enshrined in Article 3 of UDHR, and Article 21 of Indian Constitution guarantees the fundamental right to life and personal liberty. The human dignity is essence of all rights and liberties. In Mann versus Illinois, Justice Field observed that by the term life, something more is meant than mere animal justice. The Supreme Court of India has also upheld the same position in many leading judgments. Though right to life is a fundamental guaranteed right, the right to livelihood does not enjoy the same protection. Article 39A of the Indian Constitution provides that citizens shall have the right to an adequate means of livelihood. Thus, is indicative of the fact that Constitution makers were aware of such a requirement and were ready to provide citizens with basic livelihood necessities. The Mahatma Gandhi National Rural Employment Guarantee Act, MNREGA, guarantees 100 days wage employment in the financial year to a rural household whose adult members volunteer to do unskilled manual work. However, there is no such opportunity available to urban people. At present, we are aware that in order to save people's human lives, governments have declared lockdown, which have resulted in economic hardship of unprecedented labor. This is adversely affecting lower income households, most who have run out of the food and money. In USA, nearly a fifth of young children are not getting enough to eat, according to survey of their mothers by brokering institutions. The situation is grim all over the world, and there is a growing concern that saving lives cannot be at the cost of losing livelihood. and that governments have full responsibility of saving lives as well as livelihood. The distinguished speakers shall be enlightening the participants on these two issues and the best way forward. With these words, I, on my own behalf and on behalf of the management, faculty, non-teaching staff, participants, and students, extend a very warm welcome to the distinguished speakers. And we stand much obliged. Thank you very much.
Thank you so much, sir, for the welcome remarks. Now I request Mr. P.K. Malhotra, former Secretary, Union Ministry of Law and Justice, and distinguished professor of School of Law, to please guide and motivate the faculty members and the students and the distinguished guests present in the webinar, please, sir. Malhotra sir, I am audible to you, sir. I repeat, Malhotra sir, I am audible to you. प्रगति जी, मल्होत्रा सर ने ज्वाइन किया है?
He was visible, but I think must be some problem with his audio. I saw Malhotra sir, but maybe some problem with his audio.
So I will call him, sir. I will call him.
Meantime, you can request.
Hello.
Yes, sir. We can.
Am I audible?
Yes, sir.
Yes, sir. Yes, sir.
Now
Good.
Audible and visible, sir.
Yeah. Good.
Very good morning, sir.
Good morning. Good morning, participants. Honorable Mr. Justice Michael D. Wilson, Judge, Supreme Court, State of Hawaii, United States of America. Honorable Mr. Justice Swatanter Kumar, former Judge, Supreme Court of India, and former Chairman, National Green Tribunal. Professor Pradeep, Professor Yadav, other distinguished participants. It's a privilege for me to be a part of this webinar, international webinar on protection of right to life and right to livelihood during COVID-19 pandemic. I'm happy that I'm sharing the dais with the two distinguished judges, one from the United States of America and another from the Honorable Supreme Court of India, who have really contributed, and probably so far as the enforcement of fundamental rights is concerned, probably there could not have been better person to enlighten us on the subject. As the title of the webinar itself suggests, that we are talking about the protection of right to life and right to livelihood during COVID-19 pandemic. So I would like to reserve my comments only with regard to this pandemic which has taken place and the efforts which government is supposed to take to protect these human rights of the individuals, as also the responsibility and duties of the individuals to ensure that the government is in a position to enforce the right which the citizens enjoy under the law. Now, all of us know, and I think the introductory remarks by Professor Yadav and Professor Pradeep has set the ball rolling, with which by saying that every human being has an inherent right to life. Our Constitution, the Constitution of India, has declared right to life and as a fundamental right, and no one under Article 21 of the Constitution, no one can be deprived of his right to life or personal liberty except in accordance with the procedure established by law. Now, the Supreme Court has given a very wide interpretation to Article 21 of the Constitution, and I think the kind of job which Supreme Court has done in protecting the rights of the individual and the number of rights which have been read in Article 21 is unprecedented in all the constitution of the world. Take, for example, more particularly with reference to this pandemic situation, I'm saying Article 21, that is right to life, include right to livelihood, right to free movement, right to food, right to shelter, right to education, which are all essential in the present day scenario, and they are all part of the right to life. Now, the state has a duty that during this kind of situation, it must protect and ensure the right of life. That is, how that can be done? The state must adopt the measures which are necessary to safeguard the life of individuals, and others required to do all it can to prevent such individuals' life from being avoidably put to risk. Measures of the kind include guaranteeing access to food, water, medicine, and other objects which are indispensable for survival of the individual. Now, to protect this right, as I said, Supreme Court has already interpreted and read so many rights into Article 21. But once a situation emerges which is an extraordinary situation, I think that needs to be treated extraordinarily. To deal with this kind of pandemic, which is an extraordinary situation being faced by the whole world, which has led to lakhs of deaths and millions of people are affected by the coronavirus, we have in India 2 acts which empower the government to take special measure to deal with such a situation. The one is a 19th century vintage law, which is known as the Epidemic Diseases Act of 1897, and another is a 21st century law which was passed in 2005 by the Parliament, which is known as the Disaster Management Act. Epidemic Disease Act of 1897 is a pre-constitution act, but if you look at the wording of the act, it empowers the government to take all kind of steps which are necessary and which may, if we leave aside for a minute the fundamental rights given to us, all measures can be taken, and probably the kind of lockdown situation which has been declared in our country can be justified under the Epidemic Disease Act, saying that the law act empowers the government to do that. But we can't read the 1897 Act in isolation. We have to read it in consonance with the provision of the Constitution. Therefore, whatever orders are issued under the Epidemic Disease Act 1897 and the Disaster Management Act 2005 have to be in conformity with the provision of the Constitution. Now, once we are talking of the right to life, that is the individual's right, similarly, the directive principles of state policy, more particularly Article 39 within bracket small a and Article 14, which specifically put a responsibility on the state to provide adequate means of livelihood and also to ensure that every citizen get a right to work, education, and public assistance also need to be implemented. So once you are issuing directions under the Epidemic Disease Act of 1897 or the Disaster Management Act of 2005, you have to ensure that the directive principles of state policy are also given effect, as well as the fundamental right of the individual are also protected. The imposition of nationwide curfew raises I think certain crucial questions involving the fundamental right of the people. The way the lockdown was declared, the time given to the people, those who were traveling, maybe on medical ground, maybe as a student, maybe as a tourist, or for some other reason, they were all put to halt, and hardly 3 or 4 hours time was given to all these people. Was it a correct step? Does it really amount to really taking away the right to life of the individual because you are restricting the movement of the persons without giving them sufficient time? But at the same time, it also raises an issue that had the time been given, have we been able to control the pandemic the way Government of India has done? The number of cases in our country is much less as compared to the number of cases which are arising in other parts of the world. So I think that balancing has to be done. Maybe individuals or the human rights activists may say that probably sufficient time was not given, and right to life and right to livelihood of millions of people have been affected But the government may justify it that have they not taken this step, probably the kind of pandemic which have, or the kind of deaths which could have been taken place in the country, that need to be avoided, and that could have been avoided by taking immediate steps by the government. Now, of course, slowly it is being reviewed. Initially, the lockdown was for a period of 3 weeks, then it was another 2 weeks, and now another up to, I think we are having it for another week of it. And government is slowly liberalizing the condition and permitting people to be mobile. At the same time, the government has also taken steps to ensure that the people who are stranded are provided shelter and food. But are these measures enough? We have to look at the all those people also who are hello.
Yes, sir. Sir, you are audible now.
So I think
Dr.
is
Yadav,
disconnected.
you may invite the Honorable Vice Chancellor. You may invite Honorable Vice Chancellor.
Okay, sir. Very good morning to our Honorable Vice Chancellor, Dr. Sibbaram Kharaji, please. And I welcome him to this present webinar on protection of right to life and right to livelihood during COVID-19 pandemic. Sir, over to you, sir. Please give your views, please, sir. Honorable Vice Chancellor.
Thank you very much for inviting and such a wonderful topic, the protection of right to life and right to livelihood during COVID-19 pandemic. I bid my warm
Hello.
welcome. Hello, can you hear?
Hello.
Oh, sorry, come back.
Hello. Hello. Am I audible?
Malhotra sir,
You can continue.
My
This is
apology. I think we are of course successfully organizing webinars for quite some time, but unfortunately sometimes this technical glitches also create a
Yes,
problem
yes.
for us. So I would just like to conclude, because I will leave enough time for the distinguished speakers who are here. Measures taken by the government are definitely welcome, but they should not take away fundamental right of individual rights. I think India, being a welfare state, I am of the view that must ensure that in addition to protecting the right of vulnerable section of the society, small businesses also, which are also, are also extended sufficient support to enable them to restart their work. If we are compelled to act beyond the four corners of the basic laws, that is, if we are taking away the fundamental right for certain valid reasons, let us not lose focus on equally critical mandate that relief and rehabilitation of the poor and marginalized section of the society is also taken care of by the government. I think with these observations, I would like to conclude saying that yes, right to life and right to livelihood, there has to be a balance between the two. It has to be protected, and it is the obligation of the states world over to ensure that people whose rights are adversely affected, they are provided sufficient opportunity to revive and rehabilitate themselves, for which the government will have to review its policy from time to time and have to take some quick and expeditious measure to see that these rights are restored as early as possible. Thank you very much.
Thank you very much, sir. My apologies to Honorable Vice Chancellor, sir. Sir, you please continue, sir. Please continue, sir. And my apologies, sincere apologies for the technical glitch.
So thank you very much, and wonderful talks by our Secretary, Mr. P.K. Malhotra sir. I also give my warm welcome to Mr. Justice Swatanter Kumar ji, the former Chairman and National Green Tribunal, New Delhi. And also I give my warm welcome to Honorable Mr. Justice Michael D. Wilson, the Justice of Supreme Court, State of Hawaii, USA. The large number of participants and topics is very good. Probably every day we are seeing the kind of livelihood observed. Specifically those sections of the people, the industrial sector, the real estate sector, the workforce, the labor class people also we are seeing every day. And there are few issues where really India need to follow the right to life as well as right to livelihood. No concern in this present situation is during these three sectors, whereas job sectors or workforce are there, the primary, secondary, tertiary. The secondary sector, which is basically the manufacturing, production, automobile, and real estate, the worst thing, the large number of those workers are involved in these particular sectors, and we are seeing that how they are trapped in the border, how they are living their life and shelter in different places. Even they are crowding in the border of the state, another native border is unable to take them, the transport arrangement, all those kind of things. And also you have seen that for yesterday, people on the walk along the roadside, a rail line, and 8 lives we have lost. So a lot of pathetic stories are happening, and it is not just going to end with the end of the COVID-19. Probably we need to formulate some kinds of policy to safeguard all those livelihood, because tremendous impact will be there. How many of those people will get the job back? Because many people will be thinking a lot of alternative mechanism to run their organizations. As Sir has already told that the most vulnerable section, industry and then MSME, lot of policy requirement has to happen there, how we can revive, because this is the worst hit area where some kinds of Make in India, Digital India, startup, all those things were happening. And then healthcare sector. So for India, it's a very vast country and medical outreach is not at all good and very thickly populated country. So to overcome such situations and then healthcare facility and its R&D facility as well as the healthcare manforce and then infrastructures, and on top of that different healthcare related policies to make the livelihood better. I think there will be tremendous challenge after this COVID also and during this COVID as well. So I hope that many important points will be highlighted and we discussed in this forum, and it's a very wonderful topic has been chosen and arranged. And I wish you all the best for this event. Thank you very much.
Thank you very much, sir.
So thank you very much, sir. In spite of your very busy schedule, you have given us time. And just I want to inform you that today maximum number of participants, 225, have joined our webinar, sir. It is all motivation of our Honorable Dean and distinguished Professor Malhotra, sir. Now, I request Honorable Mr. Justice Swatanter Kumar, former Judge, Supreme Court of India, former Chairperson, National Green Tribunal, New Delhi, to please express his views, please. Please, I personally welcome Dr. Justice Swatanter Kumar, please, sir. I request Justice Swatanter Kumar to express his views, please.
Pragati, please unmute. Pragati, please unmute. Justice
Can you hear me?
Kumarji. Yes, sir.
Can you hear me now, please?
Yes, sir.
Okay.
We can hear you, sir. Yes, sir. We can hear you, sir.
All right. First, I would request your technical person to sum up the attendees have complained that there is a lot of disturbance. So please kindly tell him to set that effects right. Well, at the threshold, I would like to congratulate the Sharda University, the Vice Chancellor, the Dean, and Professor Yadav, Professor Kulkshetra, for having taken recourse to the useful exploitation of technology in holding this webinar on this very important topic of the day. My esteemed friend and brother, Michael and Mr. Malhotra, are two very eminent personalities who have the background of not only law, but they are very involved persons in the field of environment as well. I feel honored sharing the dais with them. Coming to the topic, protection of right to life and right livelihood during COVID-19 pandemic. See, if we see it on its plain language, you can't have a life without a livelihood. I wonder you can segregate the two. Well, the legal linguists always find a way to dissect what is indissectible. So therefore, we have two things, but surely the first question that we have to answer out of this is, do we have a fundamental right, or do we have a right either to life or to livelihood? And what is the extent? What is the extent of that right? Now, see, this is not something which is only concerned with India per se. The issue is global today. COVID-19 has taken its wrath over the globe without discrimination on any count whatsoever. Now, if we see that at the international level, first, if you see, we can go back 1948, December 1948, when the UN Charter on Human Rights was declared at Paris, and the rights of this nature came to be accepted as human rights at the global level. As far as our country is concerned, you know, to look after the people and to ensure right to life within the society was considered to be a very pious act in our heritage. The framers of our constitution made a clear distinction between placing right to life under Article 19, while they decided that all the freedoms that were essential for enjoying the right to life were incorporated under Article 19, while the right to life was made under Article 21 as an absolute right. The rights under Article 19, that is the right to movement, right to religion, right to speech, right to freedom, all are subject to reasonable restrictions, which by law can be imposed. But under Article 21, you have no authority to the state to impose any restriction. That is why, if we see why was Article 21 termed in this fashion by our framers, Please kindly have a look at the preamble of our Constitution. When we talk of the preamble of our Constitution, there we want it to be a secular, socialistic, sovereign, democratic republic. That was our status of the country. But what the preamble intended to give to its citizens is even of a greater importance. They said citizens would be given the justice, ensured the justice, which is social, economic, and political. See the wisdom of the framers of the Constitution. How can you give these three different facets of human life a complete justice? That's how it comes that first is you secure the right to life unconditionally. That means nobody should be able to check your right to breathe, your right to see, your right to enjoy your traditions. So now how was it expended? Now sometime it was termed as a judicial activism or sometimes even a judicial overreach. But it is the Indian Supreme Court which has given a new dimensions to the Article 21 of the Constitution from time to time. And if you see the legal history of our judicially, it has come in stages. It has not come at one stroke. Firstly, if we go down to when the first expansion to Article 21 was given, was in the name of case of Kharaj Singh, where the Supreme Court said that you will not have existence for 21, which is animal existence or ordinary existence. You will have an existence which is respectable, which is acceptable. Then came the Maneka Gandhi's case. Then they said right to life and right to live is right to live with dignity. And then came the Sunil Batra's case, where they said you have a right under 21 even to protect your tradition, your heritage, and your assets of society. So that is how Article 21 came to be expanded from time to time. Now you will see that is there an obligation on the part of the state to provide you with the protection of right to life or right to livelihood. The 5 judges bench in the case of Olega Tells and others versus Bombay Municipal Corporation, the Supreme Court said, and I just would like to refer to a sentence from the judgment, right to life under 21 guaranteed to the citizens of India the right to earn a livelihood, and further that the state cannot deprive the citizen of his livelihood except in accordance with a just and a fair procedure established by law. Now it is extended to livelihood. So therefore, if we see this scenario of right to life and right to livelihood, both are backed by constitutional mandate as interpreted by the Supreme Court of India from time to time. And these are, to look at from a very simple perspective, these are twin doctrines which must coexist in order to ensure that the right is of full utility and the right which is available to the citizens of our country without undue restriction and without undue hassles to the citizens, because the right given to them is a free and unrestricted right. Now, this is the judicial creativity made in our country by the Supreme Court of India, which with the passage of time has developed to this extent and places and obligations. Just now, you heard Mr. Malhotra and the professors talking about the directive principles. Now, the directive principles enforcement has again got a new dimensions, placing a higher obligation on the state to protect these rights and not to impose restrictions which are disproportionate. So the doctrine of proportionality is the essence of settling a conflict between a restriction and a right, because there is going to be ever and ever a conflict between a right and a restriction. They both cannot be said to be free of conflict. Now, once they have this conflict, then how to resolve this conflict is what the Supreme Court has shown in all these judgments, which are endless judgments coming from different scores. Now, I would just like to refer to you that what COVID-19 has done. COVID-19 has done a very, very unfortunate stroke, whether human generated or natural generated. But a professor from Harvard University, Harvard School, says that it is because we have tempered with nature too much that we are paying the cost to get COVID-19 in this extent and this fashion. To cover up, and I would, before I just go further, I would definitely like to tell you that the COVID-19 has introduced quite a serious restriction on the people of our country and across the world. In fact, the isolation is followed everywhere in the world, but these are appearing prima facie, and the courts are taking that view that it is primarily a reasonable restriction and is not an unreasonable restriction. But it is at the same time not the first time in history when the malaria came. Tihar jail case, if you recollect, in that case the restrictions were imposed even within Tihar jail. The wards were segregated, entry of the prisoners was scrutinized, and to that extent there was a challenge which was rejected by the Supreme Court as well as Delhi High Court, holding that it is not necessary to have an absolute freedom in face of crisis. So today you have this pandemic which has created a havoc in our country. Now there's some, things have been placed. There's automatically some good things have come out of it. Firstly, if you will see the habit, now what we are seeing today in this webinar itself, working from home. This has evolved as a part, as a system of our life. Secondly, there has been a greater hygiene consciousness in our country. Every colony, every institution is ensuring that level of hygiene is raised and is maintained. Then you have, which is again very important, is the waste collection and waste distribution disposal system. See how effectively it is working. You go to any street anywhere, so the generation of waste has not reduced. In fact, the domestic discharge and the waste has increased. But if you will see, there has been a better management. And then if you see the transportation system, the working from home has obviously created minimized pressure on the air quality. And therefore today you can see stars in night in Delhi. You can see the sky, you can see the sun, you can breathe. You don't have to go to the meter to see everywhere whether PM10 and PM2.5 is extremely dangerous for you to breathe. And do you need to wear a mask? Of course, today you're wearing a mask as a matter of routine, but that's for a different purpose. Now, what we can do is, if you compare the present and the post-COVID-19, the good things of COVID-19 can be followed and implemented without hesitation by the society. It has affected economic growth, socio-economic, and even the functioning there has been. That is where the right to life comes. When we talk of right to life, the most important facet today which is coming up is the migrant labor. This has been a very serious issue. If you talk of kind of this twin right being really violated to some extent, is in the case of the migrant labor, who have come in lakhs and lakhs to other states, and they are stuck. They can't go back. Now, I will refer to you just now in this context, the Karnataka, where I'm told there is a conflict arising. That is the real conflict between 1921 and economic social growth. What is happening is that now the trains were permitted to take the migrants back to their house. But now the Karnataka feels that their work which they have opened up now, because they have opened up comparatively earlier to Delhi and other places, they can't have, because the workers will leave and therefore everything will be again stand still. So there is a inbuilt conflict between the action of the state, the desire of the right exercise by the migrants, and as you, both those acts were referred to you, both pre-constitution, post-constitution, these were nothing new. We are, as a nation, quite familiar with such situations. Of course, this is a very dangerous and a very, very unfortunate disease that has come up, the virus which is taking people just, thousands a day in every part, and it takes it every part of the world. The other thing, as I mentioned to you, was that the conflict between 21 and 19 is an acceptable conflict, because the 19 article clearly, 19 is not restriction free, 21 is restriction free. So 21 must prevail. Therefore, the right to life and the right to livelihood both should be given priority over restrictions of 19. But they cannot be given a priority which will totally frustrate the action of the state for the purposes of public interest or the public health interest. If these things would not be protected, it will be very, very strange. And let me tell you, there are a number of cases. Time does not permit me to refer to all of them, but I would mention to you that there have been cases historically in our courts where restriction in such crises or pandemics have been given acceptance over limited areas of Article 21. So 21, despite being an absolute right, it is subjected to certain kind of restrictions which are very important for the purposes of understanding that we constitutionally are in such a state of way. And I just would like to show to you one slide somebody had sent to me for just telling you the impacts that has happened. Please kindly see this video. I hope can you see it?
Yes, Lordship, we can see this. Very clear water.
Yeah. Now this is River Gangaji on 26th of June in Hardwar. Now this will show you that all that has happened is that there is no dumping of waste, there is no discharge of trade effluents into the river, and the human intervention with the river has been stopped. Now, can you please just rationalize it? Now, that is what we call the principle of sustainable development. So after COVID-19, which let's all praise very early, if we are able to maintain those restrictions, that please have limited human activity interfering with the flow of the river, let there be least discharge into the river, let there be no waste being thrown into the river. This will be Ganga, where you can go to the river, drink the water. You don't need those purifying plants supply you water in bottles and make you pay for the water which you could get free because of our richness in our natural resources. You know, River Ganga has the strength to treat its own water as well as treat other dirty water. And that is what you see. It is all self-cleansingness of the river that has brought Ganga back into such a clean state of health. So we are looking into this in a very, very different way. So there are certain things which have fallen out of this, and which, if we can maintain, would be very useful to the humanity at large, to our country, and the state would have to take, and I do see what Mr. Malhotra is saying, and I'm sure Michael would also have the same view, that when you are putting restrictions, they should not lose the sense or a sense of proportionality and reasonableness. Once they are balanced, you know, that is what the whole environment theory is based upon, that the principle of sustainable development and precautionary principle, whether it's a health hazard, whether it's a pollution hazard, and pollution and health are interconnected. I think I would like to just say the last line which I heard from somebody and which I think is very true. And COVID-19 is not an exception to that rule, and we have contributed to its spreading other than what would have happened. Now see, the writer, the author, the poet says that it is the message of God to the people, to the mankind, that you are a guest on this earth and not the owner. So please remember that and protect nature, and automatically we will be able to protect such kind of serious viruses even. Now see, the hygiene, everything is paying. And I wish that this webinar brings a lot of good thoughts, and we are institutionally, these webinars are being of great use and utility, and I hope that NDs would gain little advantage out of this. Everybody, including Shavda University, please.
Thank you, sir.
Thank you, Lordship.
Thank you so much. Thank you very much, Honorable Justice Swatanter Kumar, sir, for meticulously explaining the provisions in the Constitution and informing us that the Article 21 is absolute and it doesn't have any limitation, even interpreting the framework in this context. And now I request Chief Guest of the day on Mr. Justice D. Wilson, Judge, Supreme Court, State of Hawaii, USA. I request you, Justice Michael D. Wilson, start a speech, please. Am I audible to Honorable Mr. Justice Michael D. Wilson?
Are you able to hear me from Hawaii?
Yes, sir, I can hear you, sir. I can hear you very well, sir.
Well, let me first say it's a great honor to speak to the great country of India from our state in the middle of the Pacific Ocean. And Dean Kishresta, I want to thank you for the invitation, and it was a pleasure to listen to Professor and former Secretary Malhotra. And thank you to the Assistant Dean as well. But I must take time to say hello to my great friend and also my teacher. That's Justice Swatanter Kumar, who I will speak more about in terms of his difference that he's made to judges throughout the world as well as to Hawaii. So let me ask about the presentation of the slides. Are we able to show the slides at this time? Are the slides available that I had sent for the PowerPoint?
Mr. Pragati, you may, yes, he's sharing the PowerPoint, Justice.
Thank you very much. So you can see from the PowerPoint, and starting with the first slide, in speaking about the protection of the right to life and the right to livelihood during the COVID-19 pandemic, I think we're really talking about the concept of an emergency and how the rule of law is able to contend with an emergency. And at the beginning, I want to explain that what's on my mind are all the students, primarily the students who are listening, because the word that I would be hoping you would remember at the end of this presentation is the word emergency. One of the reasons why I was very honored to speak today is because Hawaii is facing an emergency. Of course, we face the emergency of the COVID-19 pandemic. It is a very real emergency. It has shut down our economy. The governor declared a state of emergency, and in doing so, stopped the flight of airplanes to Hawaii. So you can imagine the emergency to our economy, an emergency that arises from an emergency to public health. But today I'm going to speak about the emergency that is facing the students in the audience, the young people in the audience, that I think the COVID, as my brother Justice Kumar alluded to, I think the COVID-19 pandemic is not just a wake-up call, but it's training and it's preparation for the world community about what's coming. And that training for judges has happened over the last decade, in large part as a result of India, because you have a very independent court. And as Professor Malhotra and Justice Kumar have said, your court has stood up for the people, has interpreted Article 21 in a way that gives it the strength of the law that very few laws have anywhere in the world, protecting the right to life, including a right to an environment that allows you to survive. So if you look at the next slide, it has some words that I will be discussing. And those are final stand. What's the final stand? Well, it's a way of describing the emergency that young people in India and throughout the world are in, and it's a word that was devised by students in India. And I'll talk more about the final stand. Judges as disaster managers. Justice Swatanter Kumar is one of the extraordinary justices who can think globally. As he said, this is a very global issue, but think globally with the idea that a judge has to step forward and manage disasters, such as a threat to public health or a threat to the right to privacy. Suo moto jurisdiction. To everybody in the audience, especially the students who have decided they're going to devote themselves to the law and justice. You have a power in your judiciary that is not common. Suo moto jurisdiction that can be exercised by courts originally exercised to cause action to be taken by a court, the Supreme Court, to, for example, deal with an emergency. In the United States and throughout the world, judges have to wait for cases to come to them. There's a tradition more so in the court of the country of India of actually initiating an action to protect the citizens' rights, initiating an action by judges. Earth's law is a law that's being developed around the world, but leaders of it are from India in the final stand. It's just a law that addresses the emergency that's coming, a law that requires that emissions be reduced to the point where the earth does not heat up to 1.5 degrees. And the last word is Lorenzo's answer. I have provided, along with this PowerPoint, a copy of a law review article from our law school. It's an article that I wrote as a result of a question that was asked of me by a student at the law school. What can I do in this emergency? So with that in mind, if you look at the next slide, it's a picture. It's a picture of the Court of India. Why would I have the Court of India as a slide that I show regularly in Hawaii? We don't have a chance in Hawaii to survive. In 40 or 50 years, our major city will flood. We're part of the drowning societies in the North and South Pacific. Our hope is with India and China. It used to be with the federal government of the United States, but as you know, federal government has become more of a problem in terms of protecting the world environment than a force for solution, which I will get to. So India theoretically is very important to us, but it's not just theoretical anymore. Justice Swatanter Kumar organized the Supreme Court of India, and the Chief Justice of India, Justice Thakur, came with another great member of your court who has retired, Justice Sikri. Why? Because they understand the stress that our court's under, the stress that our community's under, and the importance of standing up for the rule of law and helping judges like those in Hawaii that are in a community that's under stress. And that, when that happened, of course, it was before the coronavirus. So we are deeply grateful, and we are very connected to India, and the students in India work very closely with our law school. Many law students do. And the next slide is just a way for you to maybe see what I'm talking about. It's a slide of Hawaii from space. We are the most remote landmass on Earth. We're really vulnerable to the ocean when it rises. But one of the reasons why we have a chance is because when you think about the future, the good future that Justice Swatanter Kumar talked about, where the Ganga, a river that's sacred to over 1 billion people, is protected, that's a great future. It's an ethic, it's a value system that we need, because we represent that value system and we want to protect it. We need that value system in order to survive. And we have, supporting our value system, the concept of the ideal environment on Earth. I know all of you, as you sit there and you look at this picture, let's show the next picture. Oh my goodness. If you look at the next picture, you will have an idea why people have a reverence for the state of Hawaii. In many ways, it's similar to the reverence all of you have for the Ganga. When I hear your Chief Justice Thakur, as he did, speak at Justice Swatanter Kumar's conference 8 years ago in New Delhi, or I hear him speak today, or I hear him when I have the honor to have dinner with him and he's talking about his river, his country, it's what we need throughout the world. But it's a way that many people talk about the natural beauty of Hawaii. It's in the mind of the collective human consciousness, the ideal environment on earth. And that magnificent picture that you see there is an example of what's coming for us, because that will be gone. 40 years, that beach will be gone. Next slide. So these are treasures that you're going to see. Oh my goodness, they are amazing animals. Birds. In the ocean, we have the humpback whale, and we have dolphins. Many of them will also be gone in 30 or 40 years. So I'm sorry to belabor the word emergency, but this is the backdrop of what we're discussing today. Next slide. The emergency that is addressed in the cultures that have a rule of law that has strength, like India. The emergencies, of course, are addressed under laws like Article 21. And in the United States, we have a constitutional provision against cruel and unusual punishment. This slide points out that the coronavirus can be cruel and unusual punishment, where inmates in institutions who already have conditions that are potentially life-threatening will certainly have cruel and unusual conditions if the coronavirus enters the prison. So to put that in context and the importance in the United States, let me ask all of you in the audience to think for a second how you treat the people in India who are incarcerated. Another way to look at it is, how quick are you to put your citizens in prison? Now, as you think about that, let's turn to the United States. We have the highest rate of incarceration in the world. As an example, Russia incarcerates approximately 400 people per 100,000. The United States incarcerates 700 per 100,000. I know what you're thinking. You're asking, what does India do? India incarcerates approximately 25 people per 100,000. So it's a way of saying you're a culture that in some ways doesn't resort quite as quickly to punishment, incarceration, doesn't use your wealth in a way that takes away the rights of citizens. With so many people, over 2 million people incarcerated, we have a very big problem because they're put very close together. Turning to Hawaii, we have had 2 or 3 people in a cell. I was placed in charge of a task force for the state of Hawaii and have been working at it for a couple of years, and am frankly rather uncomfortable about what we do to the citizens that we incarcerate. Now the coronavirus has arisen. You've heard of it being so prevalent in the United States, partly because we don't act with quite the same commitment to protect incarcerated people. New York, it became a disaster. But in our prisons, we anticipate, as a result of the statistical experience we've now had, once the virus arrives in a prison, within a week, it will have infected at least 100 people, and then it goes up exponentially. So if we move to our next slide, the next slide speaks to India's Constitution, Article 21. And these are just quotes from some of your great justices. You take it very seriously. And thank you for doing that, because it's going to, I hope, continue to set an example for the world that a constitutional provision can have very few limits, if any, like Article 21 with the right to life. Next slide. But our court, our Supreme Court, was confronted with this problem with so many incarcerated citizens. So approximately 3 weeks ago, we issued an order that caused the release of citizens. And this brings up the concept of emergency that applies to the citizens that are incarcerated. And now, let me make an analogy or a comparison to the citizens that are incarcerated and those of you in the audience that are students. How do we deal with emergencies through the courts, through the rule of law. The emergency of our incarcerated people, which we determined was so severe that it was necessary to release significant numbers of them so that the numbers would be reduced and they wouldn't face the unconstitutional conditions of a coronavirus that would contaminate them when they were incarcerated. So by reducing the number of inmates, obviously they could spread out and reduce the risk. Next slide. Emergencies. Very profound emergencies are not uncommon under the law. This is an emergency that wasn't handled very well by the Supreme Court of the United States during World War II. But it's an emergency that has to do with war. It puts into context what's happening throughout the world now, because some equate the coronavirus to war. In the United States, you'll recall we had the Vietnam War, 50,000 people were killed, and now the coronavirus has killed more people than that. In this case, the Korematsu case, when we were at war, a decision was made to take people that were Japanese and move them into internment camps. And this was a case that was brought to our Supreme Court by a Japanese citizen. Keep in mind, these are Japanese citizens. They're American citizens. Keep in mind, they haven't been convicted of any crime. Keep in mind, far from committing a crime. They were law-abiding citizens with a right to life, liberty, and happiness, and they were hard-working, employed citizens. Their jobs were taken away. They were moved into internment camps. This case was brought to the Supreme Court, and there was a wonderful dissent by one of the justices that had the courage that I think your Supreme Court justices would have, that says you cannot just take a person's freedom away based on the stereotype of being Japanese. Now, there's a very famous group of Japanese soldiers that were in their squadron. They were more wounded than any other squadron in the United States. There were Japanese that were at war. At the same time, their fellow citizens were in these internment camps. And this justice just pointed out, it's not reasonable. This idea of proportionality that Justice Kumar and Professor Maltra were talking about, proportionality is a fancy way of saying you've got to have a connection between the facts and the emergency. We don't have a problem with facts in the coronavirus. It's been demonstrated that it's a virulent virus, but there wasn't proof that being Japanese meant that you were a traitor. And this was very well pointed out by this justice. What does it have to do with you in the audience facing an emergency? Because what the courts are going to do for you and your future will have a lot to do with the degree to which this proportionality applies, because you can show the reasonableness of action that's taken to protect you. Next slide. So here we are. Now we're delving into your circumstance. This is perhaps the leading scientist in the world on climate. He is an atmospheric professor at Cambridge, has been knighted by the Queen as the climate ambassador from England. He put together the Paris Agreement with Lawrence Fabius in 2015 and came up with this important figure of the Earth not heating to 1.5 degrees. Sir David King. And in 2018, he spoke to the Communist Party of China in a conference with 4,000 people, and he pointed out that the world order is pretty much going to be all over in terms of having a rule of law or having a global capitalist system in about 40 years, when 160 million people leave Bangladesh and head for India because of the rising ocean. So now we are really focused on the reality that you're facing if you are less than 40 years old, in 40 or 50 years. An emergency is coming that, next slide, David King, who now speaks more than any other public figure in England about the coronavirus because of the position that he's in and as an advisor to the government, is often asked about coronavirus versus the climate emergency, what it's going to be like when the Earth heats up over 1.5 degrees, because he is a world expert on both. And his point is humanity will recover from the coronavirus, which is a powerful statement about the fact that we may not be able to organize globally and protect ourselves once the Earth heats up above 1.5 degrees. Next slide. Now we have a choice about what to do if you are looking at this issue from a political point of view, a civil society point of view, perhaps a point of view of somebody who's an elected official. You can come up with reasons why the climate isn't a problem. We know that there is a government, unfortunately, of great power in the world that at the federal level is taking that position. You could do that, unless you're a judge. Now, these two dinosaurs, you probably figured this out, are supposed to be judges here. Now, if you were thinking of the dinosaurs when they saw the meteor about to land, they might try to pretend it's not going to be a problem or hope it's not going to be a problem. They could say, maybe it isn't going to be so bad. But judges can't act like those dinosaurs because we have to look at the facts and do our proportionality analysis and determine whether there's an emergency coming. And the emergency that's coming, as Sir David King said, transcends anything humanity has faced before. And the Supreme Court of India has the capability of telling the truth about it and entering orders that can make a difference. So next slide. If the judges in the world are able to have the kind of compassion and courage that I know I state this a lot, and I know all courts aren't perfect, but believe me, if you consider the strength and independence of the Supreme Court of India and the way the Green Tribunal used to be when Justice Kumar was in charge of it, it's a comparison that is important because that kind of comparison doesn't, if you compare other major countries, is a comparison that works very well in India's favor. So the Bangladesh emergency, suo jurisdiction, the need for the application of the survival infrastructure of the rule of law, which is the emergency infrastructure that we've been employing with the coronavirus, where we use the rule of law to protect people, even if sometimes it means they have to stay in their home, brings us to the final stand. There isn't much time, loosely speaking, 40 or 50 years. But the students of India have gathered, and the courts around the world have begun to apply an analysis that addresses this final stand, the final period we have to be able to make a difference in this next few decades. Next slide. Here's an example of a case that is meant to address the emergency facing future generations. It is the famous Urgenda case. You probably heard about it. It's a case that was decided in the Netherlands. It says the duty of the government is to protect future generations from the threat of climate change, to protect future generations from a level of carbon emission that will heat the earth up to the point where it destabilizes. Next slide. And so in Hawaii, when we had a gathering of professors of environmental law, and Lorenzo was at that conference approximately a year ago, and he asked the question when various issues were being discussed that I would consider to be cosmetic issues about how the law is developed in terms of environmental impact statements, how the law has developed in terms of the way that we identify risks and remedies. He said, what can I do about this big global picture of climate change? And the professors didn't have an answer. They're not in. They were not in the mindset of the members of this audience that are 40 years old and below. But the article that is part of the materials that I have forwarded to your great school of law includes this article that describes what a young law student or a young person can do following the course that's been set by justices like Justice Kumar to protect the earth. Next slide. So here's the final stand. It's based in India. This is the logo that was put together, and you can take down the web address. And if you Google Final Stand India, this is the #1 listing. This group of citizens who are young lawyers and law students has divided India into 4 quadrants to move forward to use the rule of law and protect the community from global warming. So I would invite you, when you get a chance, to look at the website and make contact. Next slide. So we're finishing up here with what is going to have to happen in order to use the emergency nature of the law that's being developed through coronavirus to attend to the biggest emergency that humanity has faced. And this is what has happened in the United States with the young law students who are now protesting against the Supreme Court of the United States. Our Supreme Court is taking a different direction than her agenda. Our Supreme Court is taking a different direction than the Supreme Court of India would. And they're limiting the opportunity for young people to go to court to take action against the government or take action against the parties that are causing the earth to heat up consciously. And they have joined with the Final Stand students in India. These students that you see are protesting because of the Juliana case. Next slide. Juliana case is a case in your country, you have cases as law students that you revere. Cases that have protected your life, protected the resources you care about. In the United States, we have a case like that that's called Brown versus Board of Education, in which the idea of Black community being treated differently educationally was overruled by the Supreme Court, and it created a sense of equality throughout the United States that was profound. Now, this case, the Juliana case, is the case for the present generation of young people, because it says the same thing our agenda says, which is if there's an organization, whether it's a government or a private entity, that's consciously, in other words, with knowledge, creating injury of such an existential level that it could cause the collapse of our capital, or the world capital system, as well as the collapse of environmental systems that we need to protect human health, then the action should be available in court. Our standing is being limited. Our causes of action are being limited. And so that slide that you see is an example of the final stand that is being taken by our law students and our young law professors and our young people who can't help but see what is coming and are, I think, going to be able to do something about it, but not until there's a very united effort, much like we are taking to protect ourselves from the coronavirus, where you have individuals like Sir David King that are saying this is a very important problem, the coronavirus, but we need to make sure that we learn from it, do what Justice Kumar has implied, which is change our behavior, but more importantly, have a value system that says we're going to protect the earth, because that's the only way we're going to be able to protect ourselves. And next slide. So this is the second to the last slide that I show in every slideshow, especially if it has to do with India, because this is my favorite animal. And it's a wild tiger that I was able to find as a result of some good friends that took me tiger hunting for a long time. If we can have a tiger, you know what that means for the environment. You've got to have a big, healthy environment to support a tiger. If we can have a tiger, it means, just like it's the vehicle for Druga, it means something in India that has to do with a connection to a sacredness, a connection to a higher power of great ethical dimension. And it's a kind of symbol that we need to be able to move in the direction of protecting Hawaii. In that way, the tiger, because it's such a symbol for India, can indirectly even protect Hawaii. So the last slide is a slide that is of Hawaii at sunset. The word that is used is aloha, and that's a word that basically means namaste. It recognizes the spirit in everybody, the beauty that every human spirit has, and the idea that together we get the most out of life. And together, I hope, we're going to be able to deal with these emergencies under the rule of law with a sense of integrity and a sense of courage that is part of the tradition of India. Whether you're talking about Ashoka or you're talking about Mahatma Gandhi, who laid the moral framework for a lot of our laws, you are talking about a very, very important value system that the world needs and is reflected in the way that the rule of law is interpreted. So thank you very much again for the honor of addressing all of you. And I wish you all the best, and please come to Hawaii as soon as we allow the aircraft to fly here. Thank you.
Thank you, Justice Wilson.
Thank you very much, Honorable Mr. Justice Michael D. Wilson. Justice
Thank you for
Supreme
this
Court, State of
inspiring
Hawaii,
words.
USA. Sir, there are some questions. Now we'll take question answer session. First question is for Justice Kumar, Swatanter Kumar, from Puspa Prasad. Taking into consideration of the present unsatisfied working of the states throughout the globe in dealing with life and liberty of the common people, has time come to search an alternative model of the state? Am I audible to Justice Swatanter Kumar, please?
Repeat the question, please. Can you repeat the question, please?
Taking into, yes, sir. Taking into consideration of the present unsatisfied working of the states throughout the globe in dealing with life and liberty of the common people, has time come to search an alternative model of the state?
Well, I don't quite see the sweeping decision that you propose to take, but see, every administration cannot meet such crisis single-handed. It has to be with public participation. It has to be a concerted, cooperative effort from all concerned, medical, people of the society, religious institutions. For example, as you see, the people, as I told you, in our country, the most important issue today is the migrant labor being stuck. So people should look after that class. They should cooperate with government. It's not possible for government to feed each and every person suddenly on a overnight when everything is under restriction. So it should be a collective effort. I don't think that we should arrive at a conclusion that the state has failed. I don't think that's possible, because nobody anticipated such an emergency. As Michael also said, it's a health emergency and it's a concerted effort. Judiciary should do its bit, the institution should do its bit, the government should do the maximum, other people should get together and collectively meet the demand of, taking care of. So I don't think any mode of, you have in the world, you have communists, you have total communist governments, you have presidential rules, you have prime ministers, you have different you have kingdoms, but nobody has been able to make this, absolutely clean and neat. So I don't think government model can vary meeting an emergency of this kind. I think we should only work in a concerted effort to achieve a better target. That's what my answer would be.
Thank you, sir. Thank you so much. The next question is for Justice Wilson. What can more be done? Am I audible to Justice Michael D. Wilson, please? Sir, am I audible to you, sir?
Thank you. I can hear you fine.
Thank you so much, sir. So the question is for you from Birgu Vishwakarma. What can more be done legally for making the state more responsible in the present pandemic situation? Shall I repeat the question, sir?
I think the question was, what can be done to make the state more legally responsible for the taking action to protect the community from the pandemic?
Yes.
Yes, it is correct. Yes, sir. Yes.
Yes. The role of the state, of course, is something that deserves a little bit of analysis because the state is composed of civil society and the government, and then the government has the three different branches of government. So in terms of what government can do, there is a kind of solution that would be directed towards the virus itself in the sense of providing a treatment regime for those who are most at risk, especially of spreading it throughout the community. So it seems that the government in the United States and many other jurisdictions has really focused on the first responders, because after all, they're the ones that allow for a study of and a treatment of the virus itself. So I think what government can do is to use emergency powers or pass statutes to make sure that there is a targeted way to support the doctors and the nurses and the medical technicians, and see to it that not only do they have the proper gear, but also they have the ability to do the research and produce the information about what is happening on the ground to best put the strategy together. So from a point of view of the legislative branch of government and the executive branch, I think that's helpful. But from the point of view of the courts, I think the courts can always use the support of and this happens, it seems to me, in India, can use the support of civil society when they enter orders, for example, that state that there must be a concerted effort on the part of government to supply individuals, for example, with maybe it's food, if there's a lockdown, for example. But the courts are more able to target specific problems, specific injuries, and fashion specific solutions. And of course, I am very concerned about incarcerated people, but I don't think that's quite as much of a problem in your country.
Thank you so much, sir. My next question is also for Honorable Justice Michael D. Wilson. Sir, I am audible to you, sir?
Yes, I can hear you just fine. Thank you.
Thank you, sir. Thank you so much. Mike, what's your view on the current situation in USA with respect to economic recession as well as job cut?
Well,
Shall I repeat the question to you, sir?
Yes.
What's your view on the current situation in USA with respect to economic recession as well as job cut?
Yes, I guess the question is, what is my understanding of the situation with the economy going into a recession and how perhaps to get jobs back. And this is,
Yes.
this is a issue. Thank you for asking that question, because this is an issue that does have to do with social justice. Obviously, to get the economy moving again, it's important to have a lessening of the restrictions. But the social justice aspect of it has to do with the degree to which we will do this only if we're able to protect the ordinary citizen. Because opening up the economy as wide as it could be opened up, even if it creates a resurgence of the virus, to a certain extent, doesn't affect the part of society that has the wealth and influence to stay separate. And that is a group that could benefit from opening up the economy, even if there's a resurgence. So the issue in the United States is one that's being, I think, developed with respect to the way we see relationships to each other. And I think so far it's being done in a fairly responsible way, because we have decided to provide economic support to the citizens who are suffering. And I think that this is a straightforward economic approach that's necessary to be able to get money into the economy so we don't have too much of a recession. So the overall plan is to open up the economy slowly, but stimulate the economy with a massive infusion of federal funds that will then allow for spending to keep the economy going and maybe come back.
Thank you so much, sir. My next question is for Honorable Justice Swatanter Kumar ji. Sir, am I audible to you, sir?
Yes, yes, please.
What is your view on government planning for migrant workers before declaration of lockdown? Sir, I repeat, what is your view on government planning for migrant workers before declaration of lockdown?
See, dimensions of a planning is a very, very, ongoing process. You plan a particular thing, but then during the time you come to know, no, it could have been done a little better. I don't think the planning was perfect, but I think keeping in view the situation that there was so much of emergency and suddenly you had to shut down everything in the interest of the public health, I don't think we should, try to find faults, because it's a question of everybody's health. It's not a question of migrants per se alone. They are stuck. They definitely deserve much more. And I think the government should now pay greater attention to the migrant section, migrant laborers particularly, so that they can be their health, their return to home, and other things can be worked out. That's all I would say.
Thank you so much, sir. Sir, it is a question which is addressed not to any specific guest, but in general. Sir, am I audible to all the distinct guests, please?
You may request Malhotra sir to take this.
No problem.
Okay, I will request Malhotra sir. When the life of people, sir, am I audible to you?
Yes, please.
Okay, sir. I will start the question. When the life of people is at risk, we do discuss about it. Can't we take a lesson from our own states like Kerala and Orissa, who found some amount of success in combating with this emergency situation, and there is no uniformity? Example, state decision on opening the liquor shops or not, limiting the judicial intervention act in it. This is the question.
You see, so far as India is concerned, I think we do have a very strong legal framework available with us for to deal with such a situation. Only thing is how quickly you respond to this kind of emergency which has taken place. I think that is the issue. But I think Government of India need to be complimented on this. That the moment they came to know that this is an pandemic and need to be dealt with at the earliest without bothering for other thing, the first thing done was to declare a shutdown. And this lockdown or shutdown, whatever was declared, it was done under the law passed by the parliament in 2005. And so far as the healthcare is concerned, the directions were issued in the law, which I have already discussed with you, dealing with the pandemic situation. So I think in the Disaster Management Act, there is a complete structure available to us that there is a central committee, there are committees at the state level, and there are committees at the district level to deal with this situation. Once we take a decision at the national level, that decision is binding on the authorities at the state level as well as the district level. So whatever different approaches have been taken by the states, that is keeping in view the situation prevalent in that particular state, and after getting a clearance from the central government. So if you can't sitting at the center, you can't foresee every contingency which is prevailing in a particular state. So I think this position, so far as the legal framework is concerned, it is very much in place. And probably whenever you are dealing with this kind of situation, you can't, as Justice Kumar has also said, you can't foresee every situation immediately. So you have to react with reference to the situation which is arising. And I think on that direction, we are doing well. Yes, probably so far as the migrant labor are concerned, probably some more thought could have been given. But then if the government at the central level, government at the state level, and the people at large who are affected, they take a common view, well, this is an emergent situation and probably rights which are being curtailed is a necessity or the need of the hour, then I think the way government is moving, our duty is that we should cooperate with the efforts done by the government. Justice Kumar and Justice Wilson also mentioned about it. I think this kind of situation, you can't expect government to do everything. Our duty as a citizen of the country or as a resident of the country is to ensure that the directions which are given from time to time are followed to control this kind of pandemic. And having different approaches in different states, it will depend on the need of the hour. And you cannot have a uniform practice in every direction coming from the central government to deal with a remote area where we may not have a direct information as to what are the ground realities prevalent there. So the law permits the district magistrate to take a call on that. If it is a state subject, the law permits the committee in the state headed by the chief secretary to take a call. And if it is a national level issue, then the central committee can give direction that this is the policy which should be followed throughout the country.
Thank you so much, sir. My next question is for Justice Michael D. Wilson. Is there, am I audible to you, sir? Am I audible to Justice Michael D. Wilson, please?
Yes, I can hear you just fine.
Thank you so much.
Just fine, Dean.
Is there a possibility to have a right to survive or right to existence in the right to life in the context of public health emergency and in the context of the climate crisis as in Hawaii or like island states? Shall I repeat the question?
Yeah, I think I understand the question is whether there can be a right to life or a right to existence with respect to the climate issue that's affecting Hawaii and other island states.
Yes, yes.
And thank you for asking that question, because it really has a straightforward answer, which of course there can always be such a right interpreted by the courts, but can also be the subject of what I guess I would consider to be the new legal analysis brought by the new generation. And by that I mean, think about what young people in India are facing when you have 120 million people leave Bangladesh and head for India. Or think about what the nations in the South Pacific and the North Pacific are facing as their countries get flooded. Or just, you could think, for example, about a smaller country like American Samoa, or the countries that have a legal system that is going to be, at least during the period of time where we still have an operable legal system in the next 40 or 50 years, their legal systems are going to be under a lot of stress. So the final stand in Earth's law is essentially what the question is about. There's no reason that a constitution can't be amended in a country like, for example, the Marshall Islands or Samoa, a smaller country. Now, Bangladesh geographically is relatively small. You can amend the constitution to make it absolutely clear, as some countries like Brazil and Colombia and Bolivia do, that you have got to protect the Ganga. The Ganga is the heart of India. You could have a constitutional provision that says there will be no pollution of the Ganga. Or you could have a constitutional provision that says the amount of emissions has to be set by government based on the Earth not heating to 1.5 degrees. So the opportunity to use the rule of law is the most important, you could say, opportunity for humanity. There's no stronger force to protect civilization right now than the rule of law. As we all know from what's happened, even in our country, as I said, it's caused discrimination to be eased. We had the Clean Water Act. We had the Clean Air Act. So I love the question because it makes the point, when you get a critical mass of citizens in a place like Bangladesh, maybe even India, who won't accept the status quo, which means destruction of their lives and their livelihood, you will have a change in the law that I think will be an appropriate one. And I have the feeling that it's likely that it may come from a group in India. I mean, your prime minister clearly talks about the importance of the Ganga in a way that I think is not just a political slogan. It does seem that Prime Minister Modi actually cares about the Ganga. So at a certain point, if you get enough people together, at least that could be a symbolic movement forward. You can amend the Constitution or pass laws that make it clear we are now going to set aside places in India that are our sacred heritage, and everybody could come together. So yes, I think the rule of law has got all kinds of potential to be able to formalize the value system that India has that the rest of the world needs.
Thank you. Yes. Yes, Professor
I think
Pradeep.
Dr. Yadav, I think, has some technical issue. So we had a very good webinar, and we have many questions. I see more than 100 in chat box people have put, and that will need a lot of extra time. And we had taken very limited time with the honorable justices. So with this, I think last question, I again, on my own behalf and on behalf of the management, faculty, student, participants, non-teaching staff, again extend a very warm thank you to dignitaries and participants. And I request that in future also they should keep guiding us, faculty and student, with their wisdom, so that future of the legal profession and society is bright as we foresee. Once again, thank you, sir. Thank you very much.
Thank you.
Thank you very much.
Thank you, Dean, and thank you to the faculty.
We are much obliged,
Thank you very much.
Your Lordship. We are much obliged, Honorable Justice.
It's good to see you on the other side of the world.
We are
Thank
much
you.
obliged for sparing your precious time. Thank you, Lordship.
Thank you, Professor
you.
Molcha also. And
Thank you,
I
Justice
think
Wilson.
Justice
Thank you very much.
My
Thank you.
pleasure. I hope to see you all in Hawaii eventually.
Yeah, we shall.
Aloha.
Oha. That is good.